What's up, everybody? Welcome back to another episode of The Lawyer You Know. And today we're going to give a quick update on the Lively Baldoni situation. Did Blake Lively's team just make a big mistake? Is she asking for preferential treatment? What do we think a judge is going to do? And how does this work in the mind of a litigator, a lawyer who deposes people and tries cases every day? What does something like this do to our mindset? We're going to get into all that and more in today's video. So we're going to take a look at a letter sent to the judge by Baldoni's lawyer referencing a conversation they had with Blake Lively's team. And I first saw this on Legal Bites' Twitter, and she had some interesting and funny comments about it, and I agree with most of them. But I wanted to take a second to read through this and just tell you what it's like as a lawyer if you were to know this about a client. Before you go in and take their deposition, or before you go in and question them at trial, when you're about to litigate probably what's going to be a multi-year case against them, and you start hearing things like this from the beginning, what it makes you think. And I've actually had this type of question asked in cases before, so I know how judges usually deal with it, but this is Blake Lively. This is Ryan Reynolds. Are they going to get some kind of preferential treatment? And what will the public think and say about that? Very interesting. If you can't see the words on this letter, don't worry. I'm going to read every single one of them. Dear Judge Lyman, as counsel for Wayfarer Studios LLC, Justin Baldoni, Jamie Heath, Steve Sarowitz, It Ends With Us Movie LLC, Melissa Nathan, the Agency Group PR LLC, and Jennifer Abel, collectively the Wayfarer parties, we write to advise the court of an issue that the Wayfarer parties wish to address at the upcoming conference on Monday, February 3rd, 2025. Today is Sunday, tomorrow is Monday, so we're one day away from this, which is why I wanted to get this update out today. Happy Sunday, everybody. During a conference of the parties' counsel on January 30th, 2025, just last week, counsel for the Wayfarer parties requested the earliest possible deposition of Blake Lively. Not unusual to say, hey, you're suing us. We want to take the plaintiff's deposition. I represent plaintiffs almost exclusively, and that's always, I shouldn't say always, that's almost always the first deposition. Can we set your client's depo? It'll let us know exactly what the claims are. If there were any issues or vagaries in the complaint, we'll know what their claims are. We'll know what they're alleging. You should have all that, all your ducks in a row before you even file a complaint. Same thing we say about prosecutors. Civil cases are the same. If you're going to choose to file this complaint, you have the burden. You've got to know what you have and what you can prove. So we need to take the plaintiff's deposition. And a lot of times after the plaintiff's deposition, if the plaintiff does a good job and the lawyers believe them and they feel what they're saying, and they're like, man, a jury's going to love this plaintiff, they're going to agree with them, that can sometimes settle a case. So it's not unusual at all that a plaintiff is going to be deposed. Also, if you choose to file a lawsuit and sue somebody or multiple somebodies, you're putting yourself out there. You're agreeing that you're going to sit for a deposition. You can't just say, no, I'm not going to get deposed when you file a lawsuit. Counsel for Miss Lively and Ryan Reynolds, the Lively parties, stated their objection to the Wayfarer parties' lead counsel conducting the deposition of Blake Lively. They are objecting to Brian Friedman taking Blake Lively's deposition. Specifically, the Lively parties' counsel indicated that they object to Brian J. Friedman personally taking Miss Lively's deposition based upon unspecified statements made by Mr. Friedman. When asked to elaborate on the grounds for their objection, counsel for Lively party declined to do so. So it's even worse than saying exactly why she doesn't want it. They won't tell you why. Now, we've heard, I'm going to sue her into oblivion. This was a mistake. You know, we're going to take them down, whatever it may be that we've seen Brian Friedman say publicly. We've also seen them request a gag order, which, again, you can say a gag order is appropriate, but I don't think it is when you're working with the New York Times and you're publicizing your complaints for them to do the same thing and comment and respond to it. It's kind of fair game, in my opinion. If you're going to play that way, then you got to be ready for the other side to play that way too. Number one. Number two, can you imagine if you could choose the lawyer that was allowed to depose you? I'd be like, hey, Your Honor, I'd like the crappy lawyer to depose me. Or can you give me the first-year associate at this big firm that's never taken a deposition before, Judge? Can I have him depose me? Judge, I know the defense wants to choose their own lawyer, but I'd like to choose their lawyer for me. That is absolutely not how it works. This was a major misstep, in my opinion, because it shows either a bit of weakness, fear, or entitlement. There's really no other way to look at it. And I get it. Blake Lively may not like Brian Friedman, she may think he's a scumbag, a slime ball, doesn't trust him, doesn't want to be able to ask her questions. I get that. I understand that it sucks. And there are bad lawyers out there that, have to depose my client sometimes. I'm like, it sucks. They're going to be shady. They're going to try to trick you, but just do your best and get through it. Most people don't want to sit for a deposition, period, from an experienced lawyer. So I get that. But you can obviously understand logically how this is not how it works. Now, we have had this happen before, and I've actually gotten something granted that limits not what lawyer, but how they can act. But usually only after the first deposition goes so horribly wrong, where a lawyer has screamed at my client, I've shut the deposition down, and the judge has had to give us specific rules in a future deposition if this lawyer is going to do it, or they can have a different lawyer do it, and we'll see if it goes better. So we have had this situation come up before. Another remedy that's possible, and I've heard of happening in cases, I've never had it happen in my case, I think my dad has, where you either have a judge or a magistrate sit in the deposition with you and make sure that everything that's happening in the deposition is appropriate, that no lawyer is screaming at you, taking advantage of you, doing things to harass you, because that's the number one thing. That's the only way I've ever seen a case get thrown out or a deposition blocked if the plaintiff if the defense can prove that the plaintiff, let me start that again so you're not confused. The only time I've seen it blocked is if a defendant says the plaintiff only filed this lawsuit to harass me. There's no legal cause of action. They just want to take my deposition to dig into my personal life or harass me or do this because I'm famous or because I'm the CEO of some big company. And if you can prove that early on, sometimes the judge will shut the case down before it gets to deposition because you, the defendant, is not choosing to be at issue here and take this case into litigation. But when you're the plaintiff, and you're choosing to bring this lawsuit, no lawsuit would be brought. You could have said, my deposition is not being taken because I'm not going to file a lawsuit, and you didn't. That creates a different set of circumstances. And you basically have to sit for a deposition. But if you're really afraid and you have some legitimate concerns that you can point to publicly, on the record, in filings, whatever it may be, then maybe a magistrate will sit there at the deposition to make sure you're not getting harassed and make sure everything is appropriate that's happening. So if there are objections, somebody is there to be able to say overruled or sustained in a deposition. And it's much more like a court scenario. This situation is not nearly as combative, in my opinion, as what's going on with Busby and Spyro in the Jay-Z case. You don't see anybody trying to block those lawyers from taking depositions because it just doesn't happen. And if it were to be granted in this case, it would be hard for me not to believe this is some kind of special treatment. And I think it would be inappropriate and completely unfair. Counsel for Ms. Lively has made clear that Ms. Lively does not want Mr. Friedman to be the attorney who takes her deposition. We are unaware of any stipulation that would warrant the deposed party to have a choice in which attorney takes her deposition. Parties to litigation simply do not have the right to dictate which of their opponent's attorneys may or may not take their deposition or perform any other aspect of the opposing party's case. By the way, they wrote this letter, in my opinion, to memorialize it and document it so we, the public, could see it. Because this could have just been a private conversation. Now it's going into a letter that's getting public. Don't know if I love that, right? Like you reduce every conversation to writing with opposing counsel so that the public can look at it. I don't love that. But here we are talking about it. The Wayfarer parties respectfully submit that this important issue should be discussed in the initial pretrial conference pursuant to Rule 26F3C of the Federal Rules of Civil Procedure. Pursuant to the court's individual practice in civil cases, we respectfully identify this as an area where the parties do not agree and ask that the court address the matter at the February 3rd conference. We look forward to further discussing this matter at the initial pretrial conference scheduled for February 3rd, 2025. It is an issue they need to deal with because they need to take her deposition and they need to take it early in the case to see what's going to happen afterwards. It really can affect a lot of the case. Now, for the last part, what does this do to a lawyer? What does this do to Friedman? A seasoned litigator who loves getting in the scuffle, who loves publicly talking about a case, who probably loves going after giant celebrities, representing them and suing them and defending against them. In my opinion, this gives him uber confidence. He loves this. He loves the fact that he knows now Blake Lively does not want him to depose her. I hope and I don't think he would do anything inappropriate or unethical or harassing, but he's going to come in there knowing she hates every second of this. She doesn't want this, which gives him more power, more leverage in the situation. And if you're Baldoni and the Wayfarer defendants, this has got to give you more confidence as well. You picked the right guy. You pick the one she does not want to depose, either from what she's seen you do in other cases, what she's seen you do publicly in this case, or what she thinks you're going to do. But you have to be hyper aware to not make her right. Don't make her correct that you're going to do something inappropriate, or that you're going to harass her, or that there is some legal reason you shouldn't be taking this deposition. So you do want to make her right in that she should be scared. She doesn't want you to take her deposition. You don't want her to be right in that it's legally inappropriate for you to do this deposition. So it's a fine line to walk, but experienced litigators have had this happen, and you bulldoze through and you go hammer that deposition. You come well prepared and you get all sorts of information that you're going to use to make your client successful. I found this to be extremely interesting. So I had to just do a quick video, give you my thoughts, break it down, answer some of the questions I'm getting on Twitter about it. Let me know what you guys think, and maybe we'll have some answers as soon as tomorrow or soon early in February as to whether or not Blake Lively is going to get to pick the lawyer that deposes her. Thanks for joining me. Hit that like button. Make sure you subscribe. Till next time, I'm out of here. Thanks for watching another episode of The Lawyer You Know. If you enjoyed the episode, please hit the thumbs up and share with your friends who may be interested here on YouTube. And don't forget to subscribe. You can also follow us on Instagram, Twitter, Facebook, and TikTok. And don't forget to check out the Lawyer You Know podcast with new seasons dropping every quarter. If you have a case you want to talk to us about, if it's a personal injury case, wrongful death, catastrophic injury, car accident, or slip and fall case, please email us at lawyeryouknow@gmail.com. And of course, all these links I just mentioned are included in the description below on this episode and every episode. So until next time, this is Peter Tragos, The Lawyer You Know.